Subsection 2 Effect of sale. Article 568, Effect of sale. 1. The seller shall transfer a right which has been made the object of a sale to the buyer, and the buyer shall pay the purchase price to the seller. 2. The duties of both parties mentioned in the preceding paragraph shall, unless there exists any specific agreement or custom, be performed concurrently by both parties. Article 569. Sale of right belonging to another person. In the case where a right, which has been made the object of a sale, belongs to another person, the seller shall acquire such right and transfer it to the buyer. Article 570. Sale of right belonging to another person. Seller's liability for warranty. If, in the case mentioned in the preceding article, the seller is unable, by acquiring the right he has sold, to transfer it to the buyer may rescind the contract, provided that if he was aware, at the time the contract was made, that the right did not belong to the seller, he may not claim damages. Article 571. Sale of right belonging to another person. Bona fide seller's liability for warranty. 1. If the seller was unaware, at the time the contract was made, that the right which has been made the object of a sale did not belong to him, and the seller is unable, by acquiring the right he has sold, to transfer the right to the buyer, the seller may, paying damages suffered by the buyer, rescind the contract. 2. If, in the case of the preceding paragraph, the buyer was aware at the time the contract was entered that the right did not belong to the seller may, by giving notice that he is unable to transfer the right to the buyer, rescind the contract. Article 572. Case where part of right belongs to another person and seller's liability for warranty. 1. If the seller is unable to acquire and transfer the right to the buyer by reason of the fact that a part of the right which forms the object of a sale belongs to another, the buyer may demand a reduction of the purchase price in proportion to the part. 2. If in the case of the preceding paragraph the buyer would not have bought the remaining part, had such alone been the object of the sale, the buyer acting in good faith may rescind the whole of the contract. 3. The bona fide buyer may claim damages besides claiming for a reduction of the purchase price or the rescission of a contract. Article 573. Period during which right mentioned in preceding article is to be exercised. The right mentioned in the preceding article shall be exercised within 1 year from the time when the buyer became aware of the fact, if the buyer was acting in good faith, and from the time when the contract was entered if the buyer was acting in bad faith. Article 574. Partial shortage and loss of items sold and seller's liability for warranty. The preceding two articles shall apply mutatis mutandis to the case where the articles sold by quantity show a shortage or part of the subject matter of sale had already been lost at the time when the contract was entered and the buyer was unaware of such shortage or loss. Article 575. Case where restricted real rights exist in contract and seller's liability for warranty. 1. Where the subject matter of a sale is subject to a superficies, servitude, chanseguan, right of retention, or pledge and the buyer was unaware thereof, the buyer may rescind the contract only if the objective of the contract is not unattainable thereby. In other cases the buyer may only claim damages. 2. The preceding paragraph shall apply mutatis mutandis to the cases where a servitude which has been represented as existing in favor of the immovable which is the subject of the sale does not exist or where a registered lease exists on such an immovable. 3. The rights mentioned in the preceding two paragraphs shall be exercised within 1 year from the time the buyer became aware of the fact. Article 576. Exercise of right of mortgage or chanseguan and seller's liability for warranty. 1. If the buyer has been unable to acquire or has lost the ownership of the immovable which forms the subject of a sale by reason of the exercise of a right of mortgage or chanseguan existing over such an immovable, the buyer may rescind the contract. 2. In the cases of the preceding paragraph, if the buyer has preserved the ownership at his own expense, he may demand reimbursement of such expenses from the seller. 3. Where mentioned in the preceding 2 paragraphs, the buyer may recover damages he has sustained from the seller. Article 577. Sale of superficies and chansegwan which forms subject of mortgage and seller's liability for warranty. The preceding article shall apply mutatis mutandis to the sale of superficies or chansegwan which have been the subject of the mortgage. Article 578. Sale by auction and seller's liability for warranty. 1. In the case of a sale by auction, the successful bidder may, in accordance with the provisions of the preceding 8 articles, either rescind the contract or demand a reduction of the purchase price against the obliger. 2. In the case of the preceding paragraph, if the obliger is under financial disability, the successful bidder may demand all or some of the proceeds of the sale which the obligee has received as his portion of the proceeds of the sale. 3. If, in the cases of the preceding 2 paragraphs, the obliger was aware of any deficiency in the object or right sold and nevertheless failed to disclose it, or the obligee was aware of such deficiency and demanded a sale by auction, the successful bidder may claim damages either from the obliger or obligee who was aware of such deficiency. Article 579. Sale of claim and seller's liability for warranty. 1. If the seller of a claim warrants the solvency of the obliger, he is presumed to have warranted his solvency at the time the contract was entered. 2. If the seller of a claim which is not yet due warrants the solvency of the obliger, he is presumed to have warranted his solvency at the time when the claim becomes due. Article 580. Seller's liability for warranty against defect. 1. If any defects exist in the subject matter of a sale, the provisions of Article 575, 1, shall apply mutatis mutandis, provided that if the buyer was aware of or was not aware of such defects due to his negligence, this shall not apply. 2. The preceding paragraph shall not apply to the cases of a sale by auction. Article 581. Sale in kind and seller's liability for warranty. 1. Even where the subject matter of a sale has been specified in kind, if any defects exist in the specified subject matter, the provisions of the preceding article shall apply mutatis mutandis. 2. In the cases of the preceding paragraph, the buyer may demand the non-defective item without rescinding a contract or claiming for damages. Article 582. Period during which rights mentioned in preceding 2 articles are to be exercised. The rights mentioned in the preceding 2 articles shall be exercised by the buyer within 6 months from the time when he was first aware of such fact. Article 583. Liability for warranty and concurrent fulfillment. Article 536 shall apply mutatis mutandis to the cases of Articles 572 through 575, 580 and 581. Article 584. Special stipulation for relief of liability for warranty. Even where the seller has made a special stipulation that he is not liable in respect of the warranties mentioned in the preceding 15 articles, he may not be relieved of liability in respect of any fact of which he was aware and nevertheless failed to disclose, or in respect of any right which he himself created in favor of, or assigned to, a third person. Article 585. Presumption of same time limit. If a time has been stipulated for the performance of duties of one party to a contract of sale, the same time limit shall also be presumed to have been stipulated for the other party's performance of duties. Article 586. Place of payment of purchase price. If the purchase price is to be paid in exchange for the delivery of the subject matter of the sale, the payment shall be made at the place of delivery. Article 587. Reversion of fruits and interest on purchase price. If the subject matter of a sale which has not yet been delivered produces fruits after a contract of sale has been entered, such fruits shall vest in the seller. The buyer shall pay interest on the purchase price from the day of the delivery, provided that if a time limit has been stipulated for payment of the purchase price, this shall not apply. Article 588. Buyer's right to refuse payment of purchase price where third person claims right. If a third person claims a right over the subject matter of the sale, and consequently there is a danger of the buyer's losing what he has bought in whole or in part, he may refuse payment of the purchase price to the extent of such danger, provided that this shall not apply when the seller furnishes reasonable security. Article 589. Seller's right to demand buyer to deposit purchase money. In the case of the preceding article, the seller may demand the buyer to deposit the purchase price. Subsection 3. Redemption. Article 590. Definition of redemption. 1. If the seller reserves the right of redemption at the time of the contract of sale, the seller may redeem the object of a sale by returning the purchase money received and the expenses relating to such a sale borne by the buyer. 2. If any specific agreement concerning the redemption money has been made between the parties referred to in paragraph 1, such agreement shall govern the matters concerning redemption money. 3. Unless a specific agreement has been made between the parties in the cases of paragraphs 1 and 2, the fruits of the object of the sale and the interest on the purchase price shall be deemed to have been set off against each other. Article 591. Period for redemption. 1. The period for redemption shall not exceed 5 years in the case of immovables and 3 years in the case of movables. If any period specifically agreed upon between the parties exceeds the period mentioned above, it shall be reduced to 5 years in the case of immovables and 3 years in the case of movables. 2. If a period for redemption has been fixed, it may not subsequently be extended. 3. If no period for redemption has been designated, the period shall be deemed to be 5 years in the case of immovables and 3 years in the case of movables. Article 592. Registration of right of redemption. If, where the object of a sale is an immovable, the reservation of the right of redemption has been registered simultaneously with the registration of a sale, such registration shall be effective against the third persons. Article 593. Subrogative exercise of right of redemption and right of buyer. Where a creditor of the seller desires to redeem the property in place of the seller, the buyer may extinguish the right of redemption by discharging the debt of the seller, out of the balance remaining after the amount to be repaid by the seller has been deducted from the value of the object, as assessed by an expert appointed by the court, and by paying the surplus, if any, to the seller. Article 594. Execution of redemption. 1. The seller shall lose the right of redemption unless he tenders the purchase price he received and the expenses relating to the sale to the buyer within the specified period for redemption. 2. If the buyer or any subsequent purchaser has disbursed expenses in respect of the object of a sale, the seller shall reimburse the same amount in accordance with the provisions of Article 203, provided that with respect to useful expenses the court may, upon the application of the seller, allow him a reasonable period for reimbursement. Article 595. Redemption of common share. If, after one of the co-owners of the object of a sale, in which the right of redemption has been reserved, has sold his share, and the partition of, or sale by auction of such an object has taken place, the seller may exercise the right of redemption in respect of that part or the purchase money which the buyer has received or is to receive, provided that the buyer who has not given any notice upon the partition or a sale by auction to the seller, may not set up against the seller therewith. Section 4. Contract of exchange. Article 596, Definition of Contract of Exchange. A contract of exchange becomes effective when two parties agree to exchange any property right other than money. Article 597, Supplementary Disbursement of Money. If one of the parties has agreed to transfer the property rights mentioned in Article 596 together with the additional payment of money, the provisions relating to the purchase price of a sale shall apply mutatis mutandis with respect to the money. Section 5, Loan for Consumption. Article 598, Definition of Loan for Consumption. A loan for consumption becomes effective when one of the parties agrees to transfer the ownership of money, or any other substitute, to the other party, and the other party agrees to return the same amount of money or the same kind, quality, and quantity of any substitute therefor. Article 599, Bankruptcy and Invalidation of Loan for Consumption. A loan for consumption shall cease to be effective if one of the parties has been declared bankrupt before the lender delivers the object of the loan for consumption to the borrower. Article 600, Commencement of Computing Interest. Computation of interest on a loan for consumption shall begin from the time when the borrower has received the object of a loan for consumption. When the borrower has delayed receiving the delivery of the object for a reason for which the borrower is responsible, the computation of interest shall be commenced from the time when the lender has tendered the delivery of such an object. Article 601, Loan for consumption bearing no interest and right of rescission. Either party to a loan for consumption bearing no interest may rescind the contract at any time before the object of a loan for consumption has been delivered to the borrower, provided that if damages have been caused to the other party due to the rescission of the contract, the rescinding party shall be liable to compensate for such damages. Article 602, Lender's liability for warranty. 1. If any defect is found in the object of a loan for consumption bearing interest, the provisions of Articles 580 through 582 shall apply mutatis mutandis. 2. In the case of a loan for consumption bearing no interest, the borrower may return the value of the defective object, provided that if the lender was aware of the defect and, nevertheless, failed to inform the borrower thereof, the provisions of paragraph 1 shall apply. Article 603, Time to return. 1. The borrower shall return to the lender an object of the same kind, quality, and quantity as the object borrowed at the time agreed upon by the parties. 2. If no time for the return of an object has been stipulated by the parties, the lender shall fix a reasonable period and then demand the return of the object loaned, provided that the borrower has the right to return the object borrowed at any time. Article 604, Refund of market price due to impossibility of return. If it becomes impossible for the borrower to return an object of the same kind, quality, and quantity as the borrowed one, he shall refund the value of the object at the current market price, provided that this shall not apply to the cases mentioned in Articles 376 and 377, 2. Article 605, Quasi-loan for consumption. In case where both parties are liable to furnish money, or any other substitutes, not by a loan for consumption, if both parties agree to make the subject matter the object of a loan for consumption, it becomes effective as a loan for consumption. Article 606, Loan by substitutes. If, in the case of pecuniary loans, the borrower accepts delivery of valuable instruments, or any other thing in place of money, the amount of the loan shall be the current price of the object at the time of such delivery to the borrower. Article 607, Promise to return by substitutes. If the borrower has promised to substitute any other property right in lieu of the borrowed object, the value of the substituted property shall not exceed the aggregate value of the original amount borrowed plus the interest thereon. Article 608, Prohibition of agreement prejudicial to borrower. Any agreement entered by the parties which is in violation of the provisions of the preceding two articles and is prejudicial to the borrower is not valid even if claimed as a redemption or as any other legal remedy. Section 6 Loan for use. Article 609, Definition of loan for use. A loan for use becomes effective when one of the parties agrees to deliver an object to the other party for his gratuitous use, and the taking of profits therefrom, and when the other party agrees to return such object after having used and taken profits therefrom. Article 610, Borrower's right to use and take profits. 1. The borrower shall use and take profits from the object in such a manner as is determined by the contract or by the nature of its subject matter. 2. The borrower may not allow a third person to use or take profits from the object borrowed without the consent of the lender. 3. If the borrower has violated the provisions of paragraphs 1 and 2, the lender may rescind the contract for the future. Article 611, Burden to bear expenses. 1. The borrower shall bear the ordinary and necessary expenses relating to the object borrowed. 2. Article 594, 2, shall apply mutatis mutandis to any other expenses. Article 612, Provisions to be applied mutatis mutandis. Articles 559 and 601 shall apply mutatis mutandis to loans for use. Article 613, Time to return object borrowed. 1. The borrower shall return the object borrowed at the time agreed upon by the parties. 2. If no time for the return of the object borrowed has been stipulated by the parties, the borrower shall return the object when he has completed the use thereof and the taking of profits therefrom in conformity with the purpose specified in the contract or the nature of the subject matter, provided that the lender may rescind the contract for the future at any time after a reasonable period has elapsed to allow for the specified use of the object and the taking of profits therefrom. Article 614, Borrower's death or bankruptcy and rescission of contract for future. The lender may rescind the contract for the future when the borrower has died or has been declared bankrupt. Article 615, Borrower's duty for restitutio in integrum and right to remove. The borrower shall restore the object borrowed to its original condition before he returns it to the lender, and the borrower may remove any attachments which he has attached thereto. Article 616, Co-borrower's joint obligation. When several persons jointly borrow an object or objects, they shall be jointly obligated. Article 617, Period for claiming damages and reimbursement of expenses. Compensation for damages which have arisen from the use of the object, or the taking of profits therefrom contrary to the tenor of the contract or the nature of the subject matter, and the reimbursement of expenses incurred by the borrower, shall be claimed within 6 months from the date of the return of the object borrowed to the lender. Section 7 Lease. Article 618, Definition of lease. A lease becomes effective when one of the parties has agreed to allow the other party to use an object and take profits therefrom, and the latter has agreed to pay rent for it. Article 619, short-term lease given by person without capacity or authority to dispose of property. Where a lease is given by a person who has no capacity or authority to dispose of property, its duration shall not exceed the periods mentioned below. 1. 10 years for the lease of land for the purpose of planting, collecting salt, or construction built with stone, limestone, brick, or any other similar construction. 2. 5 years for the lease of any other land. 3. 3 years for the lease of a building or any other structure, and 4. 6 months for the lease of a movable. Article 620, renewal of short-term lease. The periods mentioned in the preceding article may be renewed, provided that such renewal shall be effected within 1 year in the case of land, within 3 months in the case of a building or any other structure, and within 1 month in the case of a movable, prior to the expiration of the period. Article 621, registration of lease. 1. The lessee of an immovable may, unless there exists any contrary agreement between the parties, request the lessor to cooperate in effecting necessary formalities for the registration of the lease. 2. The lease of an immovable, if registered, shall be effective against the third persons from the time registration has been effected. Article 622. Defenses set up against third person of lease of land for which ownership of building has been registered. 1. When the object of a lease of land is to own a building, if a building on such land has been registered by the lessee, the lease of land shall be effective against a third person even if such a lease of land has not been registered. 2. If a building has been destroyed or has become dilapidated from use prior to the termination of the lease period, it shall lose the effect mentioned in paragraph 1. Article 623, lessor's duty. A lessor is bound to deliver the object to the lessee, to maintain conditions necessary for the use and taking profits of the leased object while the lease is in force. Article 624, lessor's act of preservation and duty of tolerance. The lessee may not object to a lessor who performs any act deemed necessary for the preservation of the object leased. Article 625. Act of preservation against intention of lessee and lessee's right of rescission for future. If the lessor performs an act of preservation against the will of the lessee and the lessee is thereby incapable of attaining the objective for which the lease has been obtained, the lessee may rescind the contract for the future. Article 626. Lessee's right to demand reimbursement. 1. If a lessee has made necessary expenditures relating to the preservation of the object leased, he may demand reimbursement thereof from the lessee. 2. If the lessee has made any useful expenditures, the lessor shall reimburse the lessee, to the extent that the increase in value remains subsisting at the time when the lease terminates, in the amount disbursed by the lessee or the amount by which the value of the object has been increased. In such a case, the court may, upon the application of the lessor, allow him reasonable time for settlement with the lessee. Article 627. Partial loss of object leased, and right to demand reduction of rent and right of rescission for future. 1. If part of the leased object has become unusable, or has become impossible to take profit from, due to loss or any other cause other than the fault of the lessee may demand a reduction of the rent in proportion to the part which has been lost. 2. If, as mentioned in paragraph 1, the remaining part of the object is not sufficient to enable the lessee to attain the objective for which the lease has been made, the lessee may rescind the contract for the future. Article 628. Right to demand an increase or reduction of rent. If the rent previously agreed upon by the parties has become unreasonable due to the increase or decrease of the public impost imposed upon the object leased or any other change in the economic situation, either party may demand of the other party to raise or reduce the rent for the future. Article 629. Restriction on assignment of right of lease and sublease. 1. A lessee may not assign his rights or sublease the leased object without the consent of the lessor. 2. If the lessee violates the provisions of paragraph 1, the lessor may rescind the contract for the future. Article 630. Effect of sublease. 1. If a lessee has subleased the object with the consent of the lessor, the sublessee assumes the obligations directly to the lessor. In this case, the sublessee may not set a defense against the lessor by a payment of the rent to the sublessor. 2. Paragraph 1. Shall not prejudice the exercise of the lessor's right against the lessee. Article 631. Confirmation of sublessee's rights. If the lessee has subleased the object with the consent of the lessor, the rights of the sublessee shall not be extinguished even when the contract of lease is terminated by an agreement between the lessor and the lessee. Article 632. In case where lessee allows third person to use small part of building leased. Articles 629, 630 and 631 shall not apply where the lessee of a building allows a third person to use a small part of the building leased. Article 633. Time to pay rent. Rent shall be paid at the end of each month in the case of a movable, a building, or a building site, and at the end of each year in the case of any other land, provided that in the case of a leased object which has a harvest season, rent shall be paid, without delay, upon the close of such a season. Article 634. Lessee's duty to give notice. If repairs are necessary to the leased object or a third person claims a right over it, the lessee shall notify the lessor thereof without delay, provided that this shall not apply if the lessor has prior knowledge of this information. Article 635. Notice of rescission for future of lease without fixed period. 1. If no period for a lease has been fixed, either party may give notice to the other party at any time to rescind the lease for the future. 2. Rescission of the lease for the future shall be effective upon the expiration of the periods mentioned in each of the following subparagraphs, from the day on which the other party has received the notice mentioned in paragraph 1. 1. 6 months, if the lessor has given notice of rescission of the lease to the lessee, and 1 month, if the lessee has given notice of rescission of the lease to the lessor, in the case of land, building and any other structure, and 2. 5 days in the case of a movable. Article 636. Notice of rescission for future of lease with fixed period. Even where a lease period has been fixed by the parties, the provisions of Article 635 shall apply mutatis mutandis if one or both of the parties has reserved a right to rescind the lease for the future with respect to the remaining unexpired term. Article 637. Lessee's bankruptcy and notice of rescission of contract for future. 1. If the lessee has been declared bankrupt, either the lessor or the bankruptcy trustee may, in accordance with the provisions of Article 635, give notice to rescind the lease for the future with respect to the remaining unexpired term, notwithstanding the fact that the lease contained a fixed period of rental. 2. In the cases of paragraph 1, neither party may claim damages arising from the rescission of the lease for the future with respect to the remaining unexpired term. Article 638. Notice of rescission to sublessee. 1. If a lease has been terminated by the notice of rescission with respect to its unexpired rental period, and the leased object has lawfully been subleased, the lessor may not set up a claim against the sublessee based on the rescission of the lease unless notice is given to the sublessee. 2. The provisions of Article 635, 2, shall apply mutatis mutandis where the sublessee receives the notice mentioned in paragraph 1. Article 639. Implicit renewal. 1. If the lessee continues to use the object leased, or takes profits therefrom after the expiration of the period of the lease, and the lessor fails to raise any objection thereto within a reasonable period, it shall be deemed to have created a new lease on the same terms and conditions as those of the previous one, provided that either party may give notice to the other party to rescind the lease for the future in accordance with the provisions of Article 635. 2. In the case of paragraph 1, the security for the previous lease furnished by a third person shall be extinguished by expiration of the period. Article 640. Rent in arrears and rescission of lease for future. In the case of the lease of a building or any other structure, if the amount of rent in arrears reaches the rent for 2 periods, the lessor may rescind the contract for the future. Article 641. Rent in arrears and rescission future. The provision of Article 640 shall apply mutatis mutandis to the case of a lease of land where the object is to own a building or any other structure, or is for planting, collecting salt, and stock farming. Article 642. Rescission of lease of land for future and notice to mortgage right holders. The provisions of Article 288 shall apply mutatis mutandis in the cases of Article 641 if a building or any other structure on such land becomes an object of real right granted by way of security. Article 643. Lessee's right to demand renewal of contract and right to demand purchase of building, etc. The provisions of Article 283 shall apply mutatis mutandis to buildings, trees, or any other facilities on land remaining after the expiration of the period of the lease of land where the object is to own a building or any other structure, or is for planting, collecting salt, and stock farming. Article 644. Sublessee's right to demand lease contract and right to demand purchase of building. 1. In the case of a land lease where the lessee's objective is to own a building or any other structure, or for planting, collecting salt, and stock farming, where the land has been lawfully subleased, if any building, tree or any other facilities on the land remains subsisting at the time when the periods for lease and sublease have concurrently terminated, the sublessee may demand that the lessor give him a lease on the same terms as those of the former sublease. 2. The provisions of Article 283, 2. Shall apply mutatis mutandis, if, in the case of paragraph 1, the lessor does not desire to lease his land. Article 645. Right to demand lease and right to demand purchase exercisable by lessee of land which became object of superficies. The provisions of Article 644 shall apply mutatis mutandis where a superficiary leases land which became the object of superficies. Article 646. Lessee's right to demand purchase of accessories. 1. If the lessee of a building or any other structure has attached an article to such a building, etc. with the consent of the lessor for the benefit of the lessee's use, the lessee may demand that the lessor purchase such accessories at the time when the contract of lease terminates. 2. The provisions of the preceding paragraph shall apply to the accessories purchased from the lessor. Article 647. Sublessee's right to demand purchase of accessories. 1. If, where the lessee of a building or any other structure has lawfully subleased such a building, etc., and the sublessee has attached an article to such a building, etc. with the consent of the lessor for the benefit of the sublessee's use, the sublessee may demand that the lessor purchase such accessories at the time when the contract of sublease terminates. 2. The provisions of the preceding paragraph shall also apply to the accessories purchased from the lessor or purchased from the lessee with the consent of the lessor. Article 648. Pledge for accessories, fruits, etc. on leased land, recognized by law. If the lessor of land levies an attachment pursuant to the claims relating to the lease, on a movable owned by the lessee which is affixed to the leased land, or offered for the benefit of the lessee's use, and fruits accruing from such land, it shall be effective as a pledge. Article 649, Mortgage on building on leased land, recognized by law. If the lessor of land levies an attachment on a building on his land owned by the lessee, pursuant to the claims for rent of the last 2 years, for which period rent has not been paid, such right shall be effective as a mortgage. Article 650, Pledge for accessories attached to leased building, etc., recognized by law. If the lessor of a building or any other structure attaches, pursuant to the claims created under the lease, a movable owned by the lessee and also attached to the building or any other structure, it shall be effective as a pledge. Article 651, Duration of lease contract. 1. The duration of the lease except in cases of land lease the object of which is to own a building or any other structure made of stone, limestone, brick or any other solid building or structure, or is for planting or collecting salt, shall not exceed 20 years. If the period agreed upon by the parties exceeds 20 years, the period shall be shortened to 20 years. 2. The period mentioned in paragraph 1 may be renewed. The period shall not exceed 10 years from the day on which it has been renewed. Article 652, Mandatory Provisions. Any agreement entered by the parties in contravention of the provisions of Articles 627, 628, 631, 635, 638, 640, 641, and 643 through 647 which is unfavorable to either the lessee or sub-lessee shall be void. Article 653, Special Rule applicable to lease for temporary use. The provisions of Articles 628, 638, 640, 646 through 648, 650 and Article 652 shall not apply to the cases where it is evident that a lease or sublease is given for temporary use. Article 654, Provisions to be applied mutatis mutandis. The provisions of Articles 610, 1, 615 through 617 shall apply mutatis mutandis to the cases of lease. Section 8 Contract of Employment. Article 655, Definition of Contract of Employment. A contract of employment becomes effective when one of the parties agrees to render services to the other party and the latter agrees to pay the former remuneration therefor. Article 656, Amount of remuneration and time to pay. 1. Where no agreement has been entered upon between the parties as to the amount of remuneration, custom shall prevail accordingly. 2. Remuneration shall be made at the time mutually agreed upon, but where no time has been specified, custom shall prevail. In the absence of any established custom of time, it shall be paid after the completion of the work agreed upon without delay. Article 657, Exclusivity of rights and duties. 1. The employer may not assign his rights to a third person without the consent of the employee. 2. An employee may not substitute a third person to perform his services without the consent of the employer. 3. If one of the parties violates the provisions of paragraphs 1 and 2, the other party may rescind the contract for the future. Article 658, Content of service and right of rescission for future. 1. If the employer demands of the employee some unrelated service which has not been agreed upon between the parties, the employee may rescind the contract and refuse to perform his services in the future. 2. If, where the specified services which have been agreed upon between the employer and employee require special training, experience, and knowledge on the part of the employee may rescind the contract for services for the future if the employee fails to possess the above qualifications agreed upon. Article 659, lapse of 3 years or more and right to give notice of rescission of contract for future. 1. If the period of employment agreed upon between the parties exceeds 3 years, or if it is to continue for the lifetime of one of the parties or of a third person, either party may give notice of his intention to rescind the contract of employment for the future at any time after the expiration of 3 years. 2. In the case of paragraph 1, the notice of intention to rescind the contract of employment for the future by either of the parties becomes effective after 3 months have elapsed from the date of receipt by the other party of such notice. Article 660, notice of rescission for future of contract of employment in which no period has been fixed. 1. If no period for the employment has been fixed by the parties, either party may give notice to the other party of his intention to rescind the contract for the future at any time. 2. In the case of paragraph 1, the notice of intention to rescind for the future becomes effective after 1 month has elapsed from the date of receipt by the other party of such notice. 3. If remuneration has been fixed on a set and regular periodical basis, the rescission of the contract for the future shall be deemed to be effective after 1 full period has elapsed from the date of completion of the current period during which the other party received the notice of intention to rescind the contract for the future. Article 661, unavoidable cause and right to rescind contract for future. Even where a fixed period for the employment has been set by the parties, either party may, if any unavoidable cause arises, rescind the contract for the future, provided that if such cause arises out of the negligence of one of the parties, such party is liable for damages to the other party. Article 662, implicit renewal. 1. If the employee continues to render services after the expiration of the agreed period, and the employer has not raised any objection thereto within a reasonable period, they are deemed to have entered into a new contract of employment on the same terms as before, provided that either party may give notice to the other party to rescind the contract for the future in accordance with the provisions of Article 660. 2. In the case of paragraph 1, the security furnished by a third person in respect to the former contract of employment shall be extinguished at the expiration of the first period agreed upon. Article 663, employer's bankruptcy and notice of rescission of contract for future. 1. If the employer has been declared bankrupt, either the employee or the bankruptcy trustee may rescind the contract of employment, even when a term of employment contract has been fixed. 2. In the case of paragraph 1, neither party may claim from the other any damages arising from the rescission of the contract for the future. Section 9, contract for work. Article 664, definition of contract for work. A contract for work becomes effective when one of the parties has agreed to perform a certain job and the other has agreed to pay remuneration for the result of such work. Article 665, time to make remuneration. 1. The remuneration shall be made simultaneously with the delivery of the finished object of the work, provided that if the delivery of the object of the work is not required, remuneration shall be paid without delay after the work has been performed. 2. The provisions of Article 656, 2, shall apply mutatis mutandis to the remuneration mentioned in paragraph 1. Article 666, contractor's right to demand creation of mortgage on immovable which is object of contract. The contractor for work on an immovable may demand of the person who ordered the work to create mortgage on the immovable in order to secure the contractor's claim in relation to his remuneration mentioned in Article 665. Article 667, contractor's liability for warranty. 1. If any defect exists in the completed subject matter of a work or in a certain part of the subject matter of a work which has been finished before the completion of all the work, the person who ordered the work may fix a reasonable period for the contractor to repair and rectify such defect, provided that this shall not apply if the defect is not material and if its rectification would involve excessive expense. 2. The person who has ordered the work may claim damages in lieu of, or together with, rectification of the defect. 3. The provisions of Article 536 shall apply mutatis mutandis in the cases of paragraph 2. Article 668. Contractor's liability for warranty right of rescission of person who ordered work. If, by reason of some defect in the finished subject matter of the work, the purpose of the contract cannot be achieved, the person who ordered the work may rescind the contract, provided that this shall not apply to a building or any other structure on land. Article 669. Contractor's liability for warranty release from responsibility in case defect has arisen through nature of materials supplied or instructions given by person who ordered work. The provisions of Articles 667 and 668 shall not apply if the defect in the finished subject matter of the work has arisen through the nature of the materials supplied by the person who ordered the work, or by reason of instructions given by him, provided that this shall not apply if the contractor, knowing the impropriety of the materials or instructions, has failed to notify the person who ordered the work. Article 670. Duration of warranty liabilities. 1. The demand for rectifying the defects, the claim for damages, or the rescission of the contract mentioned in Articles 667, 668 and 669 shall be made within 1 year from the day of the delivery of the subject matter of the work. 2. Where the delivery of the subject matter of the work is not required, the period mentioned in paragraph 1 shall commence to run from the day on which the work was finished. Article 671. Contractor's liability for warranty special rules applicable to land, building, etc. 1. A contractor for work with respect to land, a building or any other structure shall be liable for any defects in the subject matter of the work or in its foundations for a period of 5 years after delivery, provided that this period shall be 10 years where the subject matter of the work is made of stone, limestone, brick, metal or any other similar material. 2. If the subject matter is destroyed or damaged by reason of such defects mentioned in paragraph 1, the person who ordered the work shall exercise the rights mentioned in Article 667 within 1 year from the day that such destruction or damage took place. Article 672. Special agreement releasing warranty liabilities. Even where there was a special agreement between the parties that the contractor shall not be bound by warranty liabilities mentioned in Articles 667 and 668, he may not be relieved of liabilities with respect to the defects in workmanship or materials of which he was aware and nevertheless failed to give notice. Article 673. Right of rescission of person who ordered work before its completion. Before the completion of the contracted work, the person who ordered the work may rescind the contract at any time, but shall be liable for damages. Article 674. Bankruptcy of person who ordered work and right of rescission. 1. If the person who ordered the contracted work has been declared bankrupt, the contractor or the bankruptcy trustee may rescind the contract. In such a case, the contractor may claim in the distribution of the bankrupt estate remuneration for the part of work already completed, and for any other expenses which are not included in such remuneration. 2. Whereof paragraph 1, neither party may demand from the other party compensation for any damages which have arisen from the rescission of the contract. Section 10. Advertisement for prize contest. Article 675. Definition of advertisement for prize contest. An advertisement for prize contest shall become effective when an advertiser has expressed his intention to give a certain reward to any person who performs a certain act and a contestant has accomplished such an act as has been specified in the advertisement. Article 676. Person entitled to reward. 1. if there are several persons who have accomplished the act specified in the advertisement, the person who accomplished it first shall be entitled to the reward. 2. If 2 or more persons have accomplished the act simultaneously, each of them shall be entitled to the reward in equal proportions, provided that if the reward is by its nature indivisible, or if it has been stipulated in the advertisement that only one person is to receive the reward, the ultimate recipient of such a reward shall be determined by drawing lots. Article 677. Act done by person who was not aware of advertisement. The provisions of Article 676 shall apply mutatis mutandis where a person has accomplished the act specified in the advertisement without knowledge of such an advertisement. Article 678. Advertisement which specifies prize only for performance of highest credit. 1. An advertisement offering the reward only for one of several contestants who has performed the act in the manner deserving the highest credit shall be effective only if a certain period of definite duration is stipulated for the contest. 2. Whereof paragraph 1. The decision as to whose performance deserves the highest credit shall be made by the person designated in the advertisement. If no such designation has been made in the advertisement, the decision shall be made by the advertiser himself. 3. A decision that no performance deserves the highest credit among the contestants shall be impermissible, provided that this shall not be the case where declaration of a different intention from the above exists in the advertisement or the standards of the decision has been stipulated by the nature of the advertisement. 4. No contestant may raise objection to the decision mentioned in paragraphs 2 and 3. 5. If 2 or more persons are judged to have performed the act with the same highest credit, the provisions of Article 676 2. Shall apply mutatis mutandis. Article 679. Withdrawal of advertisement for prize contest. 1. Where a period within which the act specified by the advertiser is to be accomplished has been fixed in the advertisement, the advertisement may not be withdrawn before the expiration of such period. 2. Where of an unfixed period within which the act specified by the advertiser is to be performed, the advertiser may, until such time as a person has completely performed the specified act, withdraw the advertisement in the same manner in which it was originally effected. 3. If the advertisement cannot be withdrawn in the same manner as the advertisement was originally effected, the withdrawal may be made in any other similar manner, provided that such withdrawal shall be effective only as against persons who have become aware thereof. Section 11. Mandate. Article 680. Definition of mandate. A mandate shall become effective when one of the parties has entrusted the other party with the management of affairs and the other party has consented thereto. Article 681. Mandatary's duty of care and due diligence. A mandatory shall manage the affairs entrusted to him with the care of a good manager in accordance with the tenor of the mandate. Article 682. Restriction on right of reappointment. 1. A mandatory may not allow any third person to manage the entrusted affairs without the consent of the mandator or any inevitable reasons. 2. If a mandatory has allowed a third person to manage the entrusted affairs in accordance with the provisions of paragraph 1, the provisions of Articles 121 and 123 shall apply mutatis mutandis. Article 683. Mandatary's duty to report. A mandatory shall upon demand by the mandator report on the status of the management of the entrusted affairs, and upon the termination of the mandate he shall make a full report on the entire developments with respect to the management of the entrusted affairs without delay. Article 684. Mandatary's duty to deliver and transfer things acquired, etc. 1. A mandatory shall deliver to the mandator all the money and any other things which he has received and the fruits which he has collected therefrom in the course of management of the entrusted affairs. 2. All rights which the mandatory has acquired in his own name on behalf of the mandator shall be transferred to the mandator. Article 685. Mandatory's liability for pecuniary consumption of money. If a mandatory has spent for his own benefit any money which he ought to deliver to the mandator or which is to be used for the mandator's benefit, he shall pay interest thereon as from the day on which he spent such money, and if there are any further damages, he shall also be liable therefor. Article 686. Mandatory's right to demand remuneration. 1. In the absence of a special agreement, a mandatory may not demand remuneration from the mandator. 2. Where it was agreed that a mandatory is to receive remuneration, he may not demand it until the entrusted affairs have been completely performed, provided that if the remuneration has been fixed by periods, he may demand it after the expiration of the period. 3. If a mandate terminates in the course of performance of the entrusted affairs by the mandatory due to any cause not attributable to the mandatory, he is entitled to remuneration in proportion to the affairs already managed by him. Article 687. Mandatory's right to demand in advance payment of expenses. If any expense is required for the management of the entrusted affairs, the mandator shall, upon demand by the mandatory, pay them in advance. Article 688. Mandatory's right to demand reimbursement of expenses, etc. 1. If a mandatory has defrayed any expenses necessary for the management of the entrusted affairs, he may demand from the mandator the reimbursement of such expenses with interest thereon from the day on which they were defrayed. 2. If a mandatory has assumed an obligation necessary for the management of the entrusted affairs, he may request the mandator to perform it in his place and, if the obligation is not due, to furnish adequate security. 3. If a mandatory, without any negligence on his part, sustains damages through the management of the entrusted affairs, he may demand compensation therefor from the mandator. Article 689. Right to terminate mandate by either party at will. 1. Either party may at any time rescind a contract of a mandate for the future. 2. If one of the parties rescinds a mandate for the future without any inevitable reasons when it would be unfavorable to the other party, he shall compensate the other party for any damages occasioned by such rescission. Article 690. Death, bankruptcy, etc. and termination of mandate. A mandate shall terminate upon the death or bankruptcy of either party. The same shall apply where the mandatory is adjudged to commence adult guardianship. This article wholly amended by Act No. 10,429, March 7, 2011. Article 691. Measures for urgency at time of termination of mandate. If, on the termination of a mandate, the circumstances are of an urgent nature requiring the continuous management, the mandatory, his/her successor or legal representative shall continue to manage the entrusted affairs until the mandator, his/her successor or legal representative becomes in a position to take over the management of the affairs. In this case, the continuous management after the termination of a mandate shall be deemed to have the same effect as the original mandate. Article 692. Requirement of setting up of termination of mandate. No termination of a mandate can, whether the ground therefore exists on the part of the mandator or of the mandatory, be set up against the other party, unless the other party is given notice thereof or he is otherwise aware thereof. Section 12. Bailment. Article 693. Definition of bailment. Bailment shall become effective when one of the parties has committed to the other party the custody of money, securities or any other things, and the other party has consented thereto. Article 694. Prohibition on use of bailed articles by bailee. A bailee may not use the bailed articles without the consent of the bailer. Article 695. Gratuitous bailee's duty of care. A gratuitous bailee shall give the same degree of care in the custody of the bailed articles as he gives with respect to his own property. Article 696. Bailee's duty to give notice. If a third person alleging a claim right over the bailed articles has commenced an action against the bailee or levied an attachment thereon, the bailee shall notify the bailer thereof without delay. Article 697. Bailer's liability to redress damages arisen from nature of or any defect in bailed articles. A bailer shall indemnify the bailee for damages suffered by the bailee, as a result of the nature of, or any defect in, the bailed articles, provided that this shall not be the case if the bailee was aware of such defects. Article 698. Rescission of contract of bailment for future on which period has been fixed. If a period was fixed for a bailment, a bailee may not, in the absence of any inevitable reason, rescind a contract of a bailment for the future before the expiration of the stipulated period of time, provided that the bailer may rescind the contract at any time. Article 699. Rescission of contract of bailment for future on which no period has been fixed. If no period was fixed for a bailment, either party may rescind a contract of a bailment at any time. Article 700. Place of returning bailed articles. The bailed articles shall be returned at the place where they have been kept, provided that if the bailee has for any justifiable cause removed it to another place, he may return it at the place where the articles actually exist. Article 701. Provisions to be applied mutatis mutandis. The provisions of Articles 682, 684 through 687 and 688, 1, and 2, shall apply mutatis mutandis to a bailment. Article 702. Bailment subject to consumption. Where the bailee is allowed by the contract to consume the bailed articles, the provisions relating to loans for consumption shall apply mutatis mutandis, provided that if no time for its return has been fixed by the contract, the bailer may at any time demand its return. Section 13. Partnership. Article 703. Definition of partnership. 1. A partnership shall become effective when two or more persons have agreed to carry on a joint undertaking by making mutual contribution thereto. 2. The contribution mentioned in paragraph 1 may be made in cash or in kind, such as other property or labor service. Article 704. Partnership ownership of partnership property. The contribution made by each partner and the other property of the partnership shall belong to all the partners jointly. Article 705. Liability for any pecuniary contribution in arrears. If, where the contribution is to be made in cash, a partner delayed in making his contribution, he shall, besides paying any interest in arrears, compensate for all damages resulting therefrom. Article 706. Method of managing partnership affairs. 1. If a manager of the partnership's affairs has not been designated by the partnership contract, such a manager shall be elected with an affirmative vote of not less than 2/3 of all the partners. 2. The management of the partnership affairs shall be decided by a majority of the partners. If several managers are appointed to take charge of the affairs of the partnership, the management of the affairs shall be decided by a majority of such managers. 3. The ordinary affairs of the partnership may, notwithstanding the provisions of paragraph 2, be managed solely by any partner or any manager, as the case may be, acting alone, provided that if other partners or other managers, as the case may be, raises an objection to such acts before the completion thereof, he shall immediately suspend these acts. Article 707. Provisions to be applied mutatis mutandis. The provisions of Articles 681 through 688 shall apply mutatis mutandis to partners who manage the affairs of the partnership. Article 708. Resignation and removal of manager of partnership affairs. A partner who manages the partnership affairs may not be allowed to resign without justifiable reasons and shall not be removed from the office except with the unanimous consent of the other partners. Article 709. Presumption of representative power of managers. The partners who manage the partnership affairs shall be presumed to have a representative power of the management of the partnership affairs. Article 710. Partners' right to inspect affairs and status of property of partnership. Each partner may at any time inspect the affairs and status of the property of the partnership. Article 711. Ratio of sharing of profit and loss. 1. In the absence of an agreement between the partners as to the ratio of the sharing of profits and losses, it shall be decided in proportion to the value of the contribution of each partner. 2. If the ratio has been fixed as to the sharing of either profits or losses, such ratio shall be presumed to apply both to profits and losses. Article 712. Creditors' exercise of right against partners. A creditor of the partnership who was not aware of the ratio of the sharing of losses among the partners at the time when his claim came into existence, may exercise his right against each partner in equal shares. Article 713. Debt of insolvent partner and other partners' liabilities. If any partner does not have sufficient means to discharge his obligations, his portion shall be equally divided among other partners. Article 714. Effect of attachment of shares. Attachment of a partner's share shall be effective against the partner's right to future dividends and return of share. Article 715. Prohibition of set-off by debtor of partnership. A debtor of the partnership cannot set off his obligation against a claim which he has against a partner. Article 716. Voluntary retirement. 1. If a partnership contract provides for no fixed period of the duration of the partnership, or if it has been specified therein that the partnership shall continue its existence during the lifetime of the partners, each partner may retire at any time, provided that he may not, in the absence of any inevitable reason, retire at a time which would be unfavorable to the partnership. 2. Even when a period has been fixed for the duration of the partnership, each partner may retire, if any inevitable reason exists therefor. Article 717. Non-voluntary retirement. In addition to the cases provided for in Article 716, a partner shall cease to be such in any of the following circumstances. 1. Death. 2. Bankruptcy. 3. Commencement of adult guardianship. 4. Expulsion. This article wholly amended by Act No. 10,429, March 7, 2011. Article 718. Expulsion. 1. Expulsion of a partner may be made only with just cause and by the unanimous consent of all other partners. 2. The decision of expulsion mentioned in paragraph 1. Cannot be set up against the expelled partner until he is notified of such a decision. Article 719. Settlement of account of an ex-partner's share. 1. The accounts between an ex-partner and remaining partners shall be settled based on the status of the property of the partnership at the time when the former ceased to be a partner. 2. the share of an ex-partner may be paid out in cash irrespective of the nature of his original contribution. 3. Where of a matter having not been completed at the time when a partner ceases to be such, the account may be settled after such matters have been completed. Article 720. Demand to dissolve partnership due to inevitable reasons. Any partner may demand dissolution of the partnership if any inevitable reasons therefore exists. Article 721. Liquidator. 1. If a partnership is dissolved, the liquidation shall be conducted jointly by all the partners or by a person appointed by them. 2. The appointment of a liquidator mentioned in paragraph 1 shall be decided by a majority of all the partners. Article 722. Liquidator's way of conducting partnership affairs. The provisions of the latter part of Article 706, 2, shall apply mutatis mutandis where there are two or more liquidators. Article 723. Resignation and removal of liquidator who is partner. The provisions of Article 708 shall apply mutatis mutandis where the liquidator is appointed from among the partners. Article 724. Liquidator's duties, powers, and distribution of surplus assets. 1. The provisions of Article 87 shall apply mutatis mutandis to the duties and powers of the liquidator. 2. The surplus assets shall be distributed among the partners in proportion to the value of their contributions. Section 14. Life annuity. Article 725. Definition of contract of life annuity. A contract of life annuity shall become effective when one of the parties has agreed to deliver money, or other things, periodically to the other party or to a third person, until the end of his life or that of the other party or the third person. Article 726. Computation of life annuity. A life annuity shall be computed by the day. Article 727. Rescission of contract of life annuity. 1. If an obliger on a life annuity neglects to pay the periodical payments or fails to perform any of his other duties after he has received the principal of the annuity, the obligee on a life annuity may demand the return of such principal, provided that in such case, the obligee shall return to the obliger the balance, after interest on the principal sum has been deducted from the periodical payments already received by him. 2. The provisions of paragraph 1 shall not preclude any claim for damages. Article 728. Rescission and concurrent performance. The provisions of Article 536 shall apply mutatis mutandis to the cases mentioned in Article 727. Article 729. Death occurred by any reason attributable to obliger and declaration of continuance of an obligation. 1. If death occurs by any reason for which the obliger on a life annuity is responsible, the court may, upon the application of the obligee or his successor, declare that the obligation shall continue to exist for a reasonable period. 2. The right mentioned in Article 727 may also be exercised even in the cases of paragraph 1. Article 730. Life annuity due to testamentary gift. The provisions of this section shall apply mutatis mutandis to a life annuity effected by a testamentary gift. Section 15. Compromise. Article 731. Definition of compromise. A compromise shall become effective when the parties have agreed to terminate a dispute between them by mutual concessions. Article 732. Creative effect of compromise. A contract of a compromise shall have the effect that the rights conceded by one of the parties is thereby extinguished and the other party will, in turn, acquire the pertinent rights by virtue of the compromise. Article 733. Effect of compromise and mistake. A contract of a compromise may not be cancelled on the ground of a mistake, provided that this shall not be the case where such a mistake is concerned with the matters relating to the qualification of either party of a compromise or any matters other than those which are pertinent to the dispute subject to the compromise. Chapter 3. Management of Affairs. Article 734. Definition of management of affairs. 1. A person who manages affairs on behalf of another without being bound to do so shall conduct that management in the manner most advantageous to the principal according to the nature of such affairs. 2. If a manager knows or should have known the intention of the principal, he shall conduct the management in conformity with the intention of the principal. 3. If a manager has managed the affairs in violation of paragraphs 1 and 2, he shall be liable for the damages caused thereby even if he was not guilty of negligence, provided that if his act of management conforms to the public interest, he shall not be liable for damages unless he was grossly negligent. Article 735. Management of affairs in urgency. If a manager has managed the affairs in order to protect the principal against an imminent danger to the latter's life, person, reputation or property, he shall not be liable for any damages caused thereby, unless he acted intentionally or with gross negligence. Article 736. Manager's duty to give notice. A manager shall give notice to the principal without delay when he has commenced to manage his affairs, provided that this shall not be the case where the principal is already aware thereof. Article 737. Manager's duty to continue management. A manager shall continue the management until the principal, his/her successor or legal representative is in a position to manage the affairs, provided that this shall not be the case if it is evident that such a continuance would be against the intention of the principal or would be prejudicial to the principal's interests. Article 738. Provisions to be applied mutatis mutandis. The provisions of Articles 683 through 685 shall apply mutatis mutandis to management of affairs. Article 739. Manager's right to demand reimbursement of expenses. 1. If a manager has defrayed any necessary or useful expenses on behalf of the principal, he may demand reimbursement thereof from the principal. 2. When a manager has assumed on behalf of the principal an obligation which is necessary or beneficial to the latter, the provisions of Article 688, 2, shall apply mutatis mutandis. 3. If a manager manages the affairs against the principal's intention, the provisions of paragraphs 1 and 2 shall apply mutatis mutandis only to the extent of the principal's present enrichment. Article 740. Manager's right to claim for indemnification suffered without negligence. When a manager has suffered loss caused not by his own negligence in the course of the management of affairs, he shall be entitled to claim for indemnification to the extent that the principal is being enriched thereby. Chapter IV. Unjust enrichment. Article 741. Definition of unjust enrichment. A person who without any legal ground derives a benefit from the property or services of another and thereby causes loss to the latter shall be bound to return such benefit. Article 742. Discharge without obligation. If a person has discharged an obligation with the knowledge that no such obligation has ever existed, he may not demand the return of the subject matter. Article 743. Discharge prior to due date. If an obliger has discharged an obligation which is not due, he may not demand the return of the subject matter, provided that if the obliger discharges such obligation by mistake, the obligee shall return the benefit which he received therefrom. Article 744. Discharge without obligation which conforms to moral sense. In the event that a person, not liable to an obligation, has discharged such an obligation by mistake and such discharge conforms to a sense of morality, he may not demand the return of the subject matter. Article 745. Discharge of another person's obligation. 1. If, in the event that a person other than the obliger has discharged an obligation by mistake, the obligee has in good faith destroyed evidentiary documents, relinquished any security, or lost his claim rights by prescription, the person who has effected the performance may not demand the return of his payments. 2. In the case of paragraph 1, the person who has effected the performance may avail himself of the right to obtain reimbursement from the obliger. Article 746. Performance for illegal cause. If a person granted property or rendered service for an illegal cause, he may not demand the return of benefits resulting therefrom, provided that this shall not be the case if such illegal cause exists only on the part of the person enriched. Article 747. Cases where original object is not returnable, liability for return of value, and liability of subsequent purchaser. 1. If the person enriched is unable to return the object itself which he has received, he shall return the value of the object. 2. When the person enriched is unable to return the benefit, a third party acting in bad faith, who has obtained the object or the benefits gratuitously from the person enriched, shall be liable to return such objects in accordance with the provisions of paragraph 1. Article 748. Amount of benefits to be returned by person enriched. 1. The person enriched in good faith shall be liable to act as set forth in Article 747 to the amount that he still possesses of such benefits. 2. A person enriched in bad faith shall return the benefits received by him together with interest, and if there has been any damage, he shall be bound also to make compensation. Article 749. Recognition of bad faith of person enriched. 1. If the person enriched becomes aware of the fact that no legal ground had ever existed after he had received such benefit, he shall be liable to return the benefit as a person enriched in bad faith, from the time of his awareness of the above fact. 2. The person enriched in good faith shall, if defeated in a lawsuit, be deemed to be a person enriched in bad faith from the time such action was filed. Chapter versus torts. Article 750. Definition of torts. Any person who causes losses to or inflicts injuries on another person by an unlawful act, intentionally or negligently, shall be bound to make compensation for damages arising therefrom. Article 751. Compensation for non-economic damages. 1. A person who has injured the person, liberty or fame of another or has inflicted any mental anguish to another person shall be liable to make compensation for damages arising therefrom. 2. The court may order the guilty party to discharge the compensation mentioned in paragraph 1 by periodical payments, and may order such guilty parties to offer reasonable security in order to ensure his performance of such obligations. Article 752. Consolation money where of violation of life. A person who has caused the death of another person shall be liable for damages to the lineal ascendants, lineal descendants and the spouse, even where no economic damages exist as a result thereof. Article 753, Minor's competency. In the event that a minor has caused damage to another, if he was not in possession of sufficient intelligence to understand his responsibility for the act, he shall not be liable for damages resulting therefrom. Article 754, Competency of person of mental unsoundness. A person who, while in a state of mental unsoundness, has caused damage to another, shall not be liable for damages resulting therefrom, provided that this shall not be the case if he has brought upon himself his state of mental unsoundness either intentionally or negligently. Article 755, Supervisor's liability. 1. If a person who has caused any damage to another is exempt from liabilities under Article 753 or 754, the person who is under a legal duty to supervise such person shall be liable to make compensation for the damage, provided that the same shall not apply if the person so supervising has not been negligent in performing his/her duty of supervision. 2. A person who supervises a person who has no liability in accordance with Article 753 or 754 on behalf of a person whose duty is to supervise shall also assume the same liability as set forth in paragraph 1. This article wholly amended by Act No. 10,429, March 7, 2011. Article 756, Employer's liability for damages. 1. A person who employs another to carry out an undertaking shall be bound to make compensation for damages done to a third person by the employee in the course of the execution of the undertaking, provided that this shall not be the case if the employer has exercised due care in the appointment of the employee and the supervision of the undertaking, or if the damage would have resulted even if due care had been exercised. 2. A person who supervises the undertaking in place of the employer shall also assume the same liability as set forth in paragraph 1. 3. In cases of paragraphs 1 and 2, the employer or the supervisor may exercise the right to obtain reimbursement from the employee. Article 757, Liability of person who ordered work to be done. The person who placed an order for work to be done shall not be bound to make compensation for any damages caused to a third person by the contractor with respect to such work, provided that this shall not be the case if the former was guilty of gross negligence in placing the order or in providing instructions therefor. Article 758, Liability of possessor, owner of structure, etc. 1. If any damages has been caused to another person by reason of any defect in the construction or maintenance of a structure, the person in possession of the structure shall be liable for such damages, provided that if the person in possession has exercised due care in order to prevent the occurrence of such damages, compensation for the damage shall be made by the owner. 2. The provisions of paragraph 1 shall apply mutatis mutandis where there exists any defect in the planting or maintenance of trees. 3. In cases of paragraphs 1 and 2, the possessor or the owner may exercise the right to obtain reimbursement from the person to whom the damages are attributable. Article 759, Liability of possessor of animals. 1. The possessor of an animal shall be liable for any damages caused to another person by the animal, provided that this shall not be the case if the possessor has not neglected nor failed to give proper care according to the species and nature of the animal. 2. A person who has a custody of an animal in place of the possessor shall assume the responsibility mentioned in paragraph 1. Article 760, Liability of joint tortfeasors. 1. If two or more persons have by their joint unlawful acts caused damages to another, they shall be jointly and severally liable to make compensation for such damages. 2. The provisions of paragraph 1 shall also apply if it is impossible to ascertain which of the participants, albeit not joint, has caused the damages. 3. Instigators and accessories shall be deemed to act jointly. Article 761, Self-defense and act of necessity. 1. A person who, in order to protect his own interest or that of a third person against an unlawful act of another, unavoidably causes damages to another person shall not be liable for such damages, provided that the injured party may claim for damages in respect of the unlawful act. 2. The provisions of paragraph 1 shall apply mutatis mutandis where a person unavoidably caused damages to another person in order to avert an imminent danger. Article 762. Status of unborn child in respect of claims for damage. An embryo or fetus shall, in respect of the claim for damages, be deemed to have been already born. Article 763. Applicable provisions to be applied mutatis mutandis. The provisions of Articles 393, 394, 396 and 399 shall apply mutatis mutandis to torts claims. Article 764. Special rules which govern in case of defamation. The court may, on the application of the injured party, order the person who has impaired another's fame to take suitable measures to restore the injured party's fame, either in lieu of, or together with damages. Less than inclusion of the publication of apology in newspapers, etc. in the suitable measures to restore the injured party's fame in this article is in violation of the Constitution according to the decision of limited unconstitutionality by the Constitutional Court which was made on April 1, 1991 greater than. Article 765. Application for reduction in compensation amount. 1. The person liable to make compensation in accordance with the provisions of this chapter may petition the court for a reduction in the amount of compensation, if the damages were caused neither intentionally nor by gross negligence, and such payments of compensation shall be a severe hardship to his livelihood. 2. The court may, if the petition mentioned in paragraph 1 has been filed, reduce the amount of compensation after a study of the claimant's and obliger's respective financial situations and the cause giving rise to the damages. Article 766. Prescription in respect of right to claim for damages. 1. The right to claim for damages resulting from an unlawful act shall lapse by prescription if not exercised within 3 years commencing from the date on which the injured party or his/her legal representative becomes aware of such damage and of the identity of the person who caused it. 2. The provisions of paragraph 1 shall also apply if 10 years have elapsed from the time when the unlawful act was committed.